So the first page and the first section is on policy and principles. The policy and principles on which this bill was brought. What is its justification? So the object of the bill is to amend the Succession Act, Cap 162, to bring it in conformity with the Constitution and to reflect the current prevailing socio-economic circumstances in Uganda and internationally accepted human rights standards. So you know, the bill was, the act, the Succession Act, Cap 162, was initially an act from 1906, and since then 110, it's actually now 112 years later, the socio-economic circumstances have changed. We have women-led households, we have households that have single fathers, so the circumstances have changed, and the law as it is should speak to the circumstances of this day and of the future. Also, we have internationally accepted human rights standards like the CEDAW. We have the Universal Declaration of Human Rights. We have the Maputo Protocol for Women. That's our very own African, because people may say these are Western ideals, but we have the Maputo Protocol. All of these we have ratified. So we had to conform to them in our laws. So the current Succession Act contains provisions that are discriminatory, that was already mentioned, and it needs to be reformed to bring it in conformity with the Constitution. So the issues that need to be addressed include the gender insensitive sections, which discriminate between men and women, the definition of a child, as we'll see later on as we discuss that within this act, a child was someone who was 21 years and above, and yet our Constitution says someone is a minor until 18 years of age. And then the protection of the rights of children and surviving spouses. Not the use of the word spouses, we don't say widow or widower, all of them. And then the right of occupancy and definition of the principal residential holding also needs to be streamlined. We won't go through the defects in the existing law because we have already mentioned most of them bent towards discrimination, contrary to Article 21, that's on equality and non-discrimination. We also have obsolete clauses that because of the current times and trends, they do not apply anymore. So those also need to be removed and repealed from our current law. Several studies have been conducted and showed that this needs to be done. That summary is also included under the defects in the existing laws. We cite some cases there as authorities to back up our justification. So we go straight to the object of the bill. What does this bill seek to achieve? So the bill seeks to amend, first and foremost, the Succession Act, Cap 162. It seeks to address the gaps in the current act, including providing for gender equality in matters of succession in accordance with Articles 21 and 33. 33 deals with widows. And Parliament has an obligation to develop laws for the protection of widows, to repeal and amend sections that were declared unconstitutional by the Constitutional Court, in that case of Law Uganda versus the the Attorney General. Remove any provision that is discriminatory on the grounds of sex. Streamline the definition of minor to conform to the Constitution. I already spoke about this. Define the definition of customary heir or heiress to remove discrimination. Previously, we only provided for customary heir. Males only could become customary heirs, and their roles were not defined under the law. So there was a lot of room for abuse of power by customary heirs. This is a defect that we are choosing to clarify. Clearly provide for the protection of the principal residential holding for the benefit of the surviving spouse and lineal descendants. Lineal descendants are basically one's children or in-law, also known as issues. To revise the provisions relating to domicile of spouses upon marriage. To revise the percentages of distribution of the estate of an intestate to increase the percentage of a surviving spouse. To provide for the appointment of guardians for minor children by either parent, and to provide for the powers and duties of guardians. To provide for the lapse of probate of letters or letters of administration after 3 years. So after 3 years as an administrator or an executor or executrix of a will, you're supposed to have concluded your business with the estate and concluded, and your letters of administration or grant of probate will expire unless you apply to court for an extension. So to repeal provisions that have become obsolete, we mentioned that. To revise and update fines and penalties to take into account inflation. Some of the penalties in the law currently, let me not even say previously, this is me being hopeful. Some of the penalties in the law that we have right now are as low as 3,000 shillings. We even have one of 200. Yes. So these are not what is it called when you want to dissuade people from committing offences? They are not deterrent or punitive enough. So we have to change that, and now you should feel the effects of you abusing a deceased estate. So that has also been revised and updated, and to provide for related matters around succession. That is basically our memorandum, and that is what will be read by Honorable Kajungo Mutambi during the first reading. I hope it's okay. I think it is. We'll just